This is the first real turning point for millions of Americans waiting for their SNAP reloads. After weeks of uncertainty, fear, and frustration, a federal judge has stepped in with a powerful message to Washington. People have gone without for too long. Judge John McConnell Jr. of Rhode Island ordered the Trump administration to pay the full $9 billion necessary to restore November food stamp benefits to more than 42 million Americans. For families that have been skipping meals or rationing groceries, this ruling means the difference between surviving and falling deeper into crisis. It's not just about money, it's about dignity, nutrition, and keeping children fed while politics play out in Washington. Before we dive deeper, I want you to hit that like button, subscribe to Social Security Post, and comment your state and situation below. Are your November SNAP benefits showing up? Are your EBT cards reloading yet? Your comments help others across the country see which states are processing payments the fastest. Let's share information, help each other through this shutdown, and stay informed together. On November 6th, Judge McConnell issued an emergency oral order directing the U.S. Department of Agriculture to immediately pay states the $9 billion needed for November's SNAP benefits. He gave the department a deadline of November 7th to send the money, making it clear that further delay was unacceptable. This decision came after the Rhode Island State Council of Churches and other advocacy groups filed suit, arguing that withholding these funds violated the judge's earlier order and left millions of Americans in limbo. The ruling marks the first time in history that a federal court has explicitly compelled the executive branch to release SNAP funding during a government shutdown. This moment underscores the urgency of protecting essential programs when political gridlock stops everything else. McConnell's order wasn't about politics, it was about people. He stated that the government had both the legal authority and financial ability to fund the program, and that continuing to withhold payments caused irreparable harm. That language matters because it signals the court's recognition that hunger can't wait for politics. His order now forces the administration to comply swiftly, putting immediate pressure on the USDA to unlock those funds. The current food stamp crisis didn't start overnight. When the government shut down, the USDA halted routine funding transfers to states, claiming that it couldn't legally disperse benefits without new congressional appropriations. That decision left tens of millions of households uncertain about whether they'd receive their November assistance. Grocery stores started warning of possible EBT outages. Food banks began running out of supplies, and some states even considered using local emergency funds to prevent hunger among children and seniors. The tension was visible in every community, from small-town markets to urban neighborhoods, where people depend on that EBT deposit just to get through the week. In reality, the USDA did have money, just not the will to use it. The department maintained more than $4 billion in its contingency fund and had access to billions more in tariff revenue through Section 32 accounts. But officials insisted those funds could not legally be tapped, creating confusion and panic. Legal experts, however, argued that these funds were specifically designed for emergencies just like this. As the shutdown dragged on, the pressure grew for someone to intervene. And that's exactly what Judge McConnell did. Before this decisive ruling, Judge McConnell had already issued a temporary restraining order on November 1st requiring partial SNAP payments by November 5th. That earlier order was meant to prevent a total lapse in benefits. Yet the USDA failed to meet even that limited requirement, citing administrative burdens and paperwork delays. The agency argued that processing partial payments would take weeks, not days. To the judge, this sounded like an excuse and one that was costing families real meals. When he saw that his temporary order was being ignored, he escalated the issue with the much stronger directive now forcing full funding. The judge's frustration was clear. He said that government officials were hiding behind bureaucracy while families suffered. In court documents, the USDA itself admitted it could take weeks or even months for all recipients to get their partial November benefits. That admission became the breaking point. By refusing to follow the first court order, the administration left the judge with no choice but to remove their discretion entirely, transforming a may fund situation into a must fund order under federal law. At the heart of this case lies a debate over two major funding sources: The first is the $4.6 billion contingency fund, which was created to provide emergency food assistance during natural disasters or temporary crises. The USDA said it would use that to pay half of November's SNAP benefits, but argued it couldn't go further. The second source is tariff revenue, or Section 32 funds, which come from duties on imported farm goods. That money normally supports child nutrition programs like school lunches. The judge ruled that together these two funds could legally cover the full month of benefits. However, USDA officials refused to touch the Section 32 account, saying it could endanger future school meal programs if the shutdown lasted months. Plaintiffs countered that the risk was wildly exaggerated. The account wouldn't run dry unless the shutdown extended until at least June of next year. In other words, there was plenty of money available to feed hungry families right now. This debate became symbolic of Washington's broader problem, treating food assistance as a bargaining chip instead of an emergency priority. The lawsuit was led by the Rhode Island State Council of Churches along with several public interest groups representing low-income families. They argued that the administration's refusal to fully fund SNAP was arbitrary, capricious, and unlawful under the Administrative Procedure Act. Their lawyers presented evidence showing that people were already going hungry, local shelters were overwhelmed, and food pantries were at record demand. They said that when the government has money set aside for emergencies, it cannot simply choose not to use it, especially when people's health and safety are on the line. Attorney Kristen Bateman spoke directly to the moral and legal urgency, telling the court that there's no more time to wait. She argued that the USDA's decision to hold back tariff funds had no factual basis, pointing out that tapping those reserves now would not threaten any future child nutrition programs. Her argument struck a chord with the judge, who agreed that the agency's reasons for withholding full funding were weak and unsupported. The plaintiff's victory here sends a message: the law must protect people before politics. Government attorney Tyler Becker tried to convince the court that the USDA had met the earlier order by sending contingency funds to state agencies before the deadline. His defense was simple: the money is already out there. If people don't have it yet, that's a state problem. But this argument backfired. The judge quickly pointed to the government's own filings, showing that many families wouldn't see any funds for weeks or even months. That meant the USDA had not actually complied in plain language with the court's order, which required immediate payments, not just transfers on paper. Judge McConnell made it clear that the federal government could not shift blame to states for a delay it caused. SNAP is a joint federal-state program, but it depends entirely on Washington's funding decisions. Without full disbursement from the USDA, states cannot reload EBT cards or distribute benefits. The judge's rejection of the state problem claim not only forces immediate action, but also reaffirms that the federal government carries ultimate responsibility for feeding its citizens during national emergencies. In his ruling, Judge McConnell emphasized that this would have been the first lapse in SNAP benefits in U.S. history, something he described as entirely avoidable. He concluded that the administration had both the resources and the authority to prevent harm but chose not to. By missing deadlines and disobeying prior orders, he said, the government forfeited its discretion over how to use those funds. That's a critical legal distinction. Once irreparable harm occurs, the court can step in to compel action. In simple terms, the judge removed choice from the equation and replaced it with obligation. The consequences are significant. The order now legally binds the USDA to issue full November payments, with no room for further delay. If the agency fails to comply, it could face contempt of court proceedings or new injunctions. This marks one of the strongest judicial interventions into federal welfare administration in decades, showing that courts can and will act when politics leave Americans hungry. It also restores some faith in the system for millions who felt abandoned during the shutdown. Shortly after the ruling, President Trump posted on Truth Social that SNAP benefits will not be paid until the government reopens, a statement that directly conflicted with the judge's order. The post sparked outrage and confusion, suggesting the White House might defy the court. However, Press Secretary Caroline Leavitt later clarified that the administration was in full compliance. but that people needed to be patient because payments would take time to process. She said the president was frustrated about tapping into contingency funds meant for war and catastrophes and blamed Democrats for forcing his hand. The White House messaging reflected internal tension. On one hand, officials said they were complying. On the other, they continued criticizing the court's decision and the need to use emergency funds. USDA staffers privately admitted that they were under pressure to execute the judge's order quickly while facing logistical challenges from the shutdown. For families waiting on those EBT reloads, the political arguments don't matter. What matters is whether groceries can be bought this week or not. With this ruling, the USDA is required to release the full $9 billion immediately. State agencies have already begun preparing payment schedules, but the timeline will vary. Some states may process benefits within days, while others could take up to a week. That's because they must reconcile partial payments already made with new full funding transfers. Still, the decision guarantees that no family should miss their November assistance entirely. For 42 million participants, this is the first sign of stability after weeks of uncertainty. Economists estimate that every dollar of SNAP spending generates about $1.80 in local economic activity, meaning this infusion of funds will also help grocery stores, farmers, and truck drivers. Local economies in rural and urban areas alike depend on this flow of benefits. The judge's decision, therefore, isn't just a legal victory, it's an economic lifeline. It restores consumer spending and confidence during a time when both are in short supply. Beyond November, this case exposes a major structural weakness in how SNAP is funded. Unlike Social Security or Medicare, SNAP relies on annual appropriations from Congress. That means every shutdown puts it at risk. Advocates are now calling for permanent mandatory funding to ensure that food assistance continues, even when Washington gridlocks. This case may push lawmakers to introduce new protections that treat hunger relief as a non-negotiable national priority. Policy analysts also say the ruling highlights how quickly the judiciary can act when executive discretion fails. It sets a precedent for other programs like housing vouchers or Medicaid reimbursements that could face similar disruptions. In short, the message is clear. When basic needs are on the line, the courts can compel government action. It's a historic moment that will shape future emergency funding debates long after this shutdown ends. While November's payments are now secured, December remains a major question mark. The contingency fund will be nearly exhausted after this round, and without new congressional action or another court ruling, the USDA will again face a funding shortfall. Lawmakers from both parties are already drafting temporary resolutions to extend spending and prevent another lapse. But progress is slow. This means recipients should stay alert and follow updates closely in case new payment delays arise. Still, there's hope. This ruling proves that the system can work under pressure and that the voices of advocates, churches, and citizens make a difference. It also reminds us that SNAP isn't a handout. It's an economic stabilizer that supports working families, seniors, and veterans when times get hard. The coming weeks will determine whether this victory becomes a one-time reprieve or the foundation for lasting reform. So, what do you think about this historic ruling? Do you believe it's a temporary fix or a turning point for America's safety net? Comment your state and SNAP status below. Has your EBT card reloaded yet, or are you still waiting? Your experiences help others across the country understand what's really happening on the ground. Make sure you like this video, subscribe to Social Security Post, and turn on notifications so you never miss a major update about SNAP, Social Security, or SSI payments. Together, we can stay informed, share accurate facts, and hold leaders accountable, because no one in America should ever go hungry while the funds to feed them are sitting in Washington.